So, I want to go to an event in April 2009.
Chair, I think we need a private meeting. And I'll put that to the rest of the committee through you.
About an
So you're ignoring me, Chair?
Parafield.
So you're just going to ignore me?
No, I'm not.
Well, I request it. I'm putting to you. I request a private meeting.
When I'm finished, we'll deal with it.
So what does that mean? I can go jump, in other words? You're not going to have it. You're going to sit there and ask these questions. Is that what you're going to do, regardless of the thoughts of the rest of the committee? Is that what you're doing?
When I finish this particular matter, we'll go into a private
What,
meeting.
in this particular matter, could go for the next half hour, Chair, or is it just 1 minute?
No, I just want to deal with a company. Well, let me put a proposition to you. Are you aware of instances of the borrowing of AOC?
In general terms, Senator, yes.
Is that illegal?
Again, I'll ask Dr. Alley to give you the legal
The term is a little problematic. There are circumstances in which operations can be conducted under another person's AOC, but the terms and conditions that govern that are specified in the civil aviation orders.
Could you set out the circumstance in which it is possible for someone that doesn't have an air operator certificate to conduct charter flights with a leased plane in the name of a company that doesn't have an air operator certificate?
I'd need to take that on notice, Senator.
But you are aware that it happens?
I am aware that there are circumstances under which operations, under which what are sometimes referred to generally as borrowed AOCs, can be conducted lawfully. There are circumstances under which such operations are not lawful.
According to my information at Bankstown, this particular person found 25 companies or individuals who did not have an AOC, and the Bankstown office has not dealt with these issues. I found 2 CASA employees, one in breach of 206 and 210, the other a CASA employee who was writing support documents when having a directorship of a company that had applied for CASA for a new AOC. CASA, I understand, has dismissed the second employee but not had the person charged under CAA 20AC, purported issue of an authorisation. CASA further issued the AOC to the company of which this employee is a director. Both surely are a gross dereliction of duty and malfeasance in public office. That is the nature of some of the material I have here, and I would now suggest we go into private meeting.
I just had some other questions to do with the show cause notice, just for the sake of completeness, if I may. With the show cause notice involving Tiger, was any information in relation to show cause notice provided to anyone outside CASA and outside Tiger?
I can't speak for Tiger, Senator.
No, sorry. In terms of your knowledge, in terms of, obviously you don't know what happened with the information once it went to Tiger, but with show cause notices, do they go, where else do they go apart from the airline that they're directed to?
The show cause notice process within CASA is from the field office, which is directing, that has direct oversight of the particular operator in question, and of course that comes under, in this case it's Mr McGregor, and it comes under CASA operations, which of course is Mr Greg Hood as the executive manager, and myself and the 2 people to my left and right would also know about it.
Is the Minister's office advised of a show cause notice? What's the standard operating procedure there?
I keep the Minister's office advised of issues which I think are of interest to the Minister and to the Australian public.
Which is entirely appropriate. I'm saying, as a matter of protocol, something of the magnitude of a show cause notice, is that something that the Minister's office would be advised of?
Well, CASA is, of course, as you know, an independent statutory authority, and we do operate at arm's length from the government as such.
Absolutely.
And our priority is the regulation of aviation safety. But we're cognizant of the fact that we work within the portfolio, and if there are issues which I deem of sufficient gravity to inform the Minister's office, then I would inform the Minister's office.
No, I understand it, and there is, and I think that's entirely appropriate. I don't take issue with you in anything that you've said. I just wonder whether there is a protocol for something like a show cause notice for the Minister's office to be advised as a matter of course, or is that on a case-by-case basis?
I think going by the numbers that I think Dr. Alec gave you before on the number of show cause notices we issue, a lot of them do not reach any action from our part of, as a catch-all term. Our protocols with the Minister's office, I think, are standard with virtually any department, and that we keep the Minister's office informed of our activities on a weekly basis. And we, of course, publish our plans via the plan and via the internet.
As is entirely appropriate, but with a show cause notice for a high capacity passenger airline, is that the sort of thing that the Minister, in your view, ought to know about?
Yes.
So that would be the standard protocol. If it's for a large airline in this country, you'd let the Minister's office know.
Yes.
Because I imagine any minister would be unhappy if they didn't know about it. I guess you know, in terms of standard, something as significant as that, they'd want to know about it.
I agree with you.
Yeah, yeah. So that's why you let them know. Going back to the ACAO approach, has Australia formally adopted the ACAO approach to just culture? Is that part of the framework that I referred to, the ACAO approach to just culture? Is that a guide, or is it something that's been formally adopted? What weight does the ACAO guide have?
I'll defer to Dr. Alec to your
merely
conversation.
advisory.
Sorry?
The guidance material to which you refer is guidance material. There is no process by which ICAO would expect it to be formally adopted, and we have not formally adopted the material in that manual. We certainly refer to it, we rely on it, but we're not bound by its terms. And as I said before, Senator, that particular area is an area that is under review by ICAO itself.
And perhaps a question on 6 months' notice when the next estimates. I'd be interested to find out what the progress of that is in terms of whether that document's being altered in any way.
We'd be happy to share that.
No, I'd be very interested. And I think, and finally for me, I asked whether there were any other show cause notices current for high capacity passenger airlines. Are you in a position to answer that?
We're still looking at that, Senator. Our breakdown didn't break down between high capacity, low capacity or charter. They were all put together.
Sure, but in terms of high capacity, let's make sure a definition is anything more than 50 seats. What's the definition of high capacity?
We haven't issued any other show cause.
We have not issued any other, or we have not. There are no currently any. I'll start again. There are currently no show cause notice issued to any other high capacity RPT operator.
Right, that's it. Very grateful for your answers. And Chair, are we having a private meeting now? Or what are we doing?
I just want to raise one other issue. Are you aware of maintenance providers borrowing licences?
Meaning Car 30 approval licences or individual? Sorry to ask the question.
To put some context in it, this particular, prior to the event in 2009, I sought information from your regulator, and despite 5 calls to CASA, I was unable to get the Parafield provider, who I won't name, investigated. Finally, I pressed the matter further. CASA officer involved investigated after 18 months, and this particular operator handed in its so-called licence. This particular operator had been borrowing a licence from another organisation which it part-owned, and so it goes on. So these are a series of issues which the committee is pretty agitated about. And so
Chair,
could I finally just go to put you on notice that the Goulburn Flight Training Centre and the parachuting operation out of there, where application was made, and one of the directors is an employee of CASA. I want to deal with that as well. Also, an employee of CASA and a director of the company that's making the application. And with that, we'll go into.
And will you table that document that you've got?
We'll go into private meeting.
Will you table it? Because we've got no idea what you're talking about.
We could just suspend and go into a private meeting. Thanks.